Mm-mm. Okay. Good morning.
Good morning.
Okay. The time is now 10:01 a.m. and I will call the meeting of the District of Columbia Board of Ethics and Government Accountability to order. I'm Bega Chairperson Norma Hutcheson. This meeting is being held at the Board of Ethics and Government Accountability at 1030 15th Street Northwest, Suite 700 West, and virtually. Joining me today for this meeting are board members Charles Nottingham, Felice Smith, Darrin Sobin, who is with us virtually, and Melissa Tucker. Together, the five of us constitute a quorum for this meeting. Since it was first posted, there have been no changes to the agenda, so I ask board members to please take a minute to review the agenda, and then we'll need a motion to adopt the agenda.
I'll offer the motion that we adopt the agenda for today's meeting.
Okay, is there a second?
Second.
Okay, it's been moved and seconded that we adopt the agenda for today's meeting. All in favor, please indicate by saying aye.
Aye.
Any
Aye.
nays? Hearing none, the board has adopted the agenda for today's meeting. Before us today are the July 2025 draft meeting minutes. Please take a moment to review those, and then we'll need a motion to approve the meeting minutes.
Make a motion to adopt meeting minutes. Second.
Okay, it's been moved and seconded that the board consider the approval of the July 2025 meeting minutes. All in favor, please indicate by saying aye.
Aye.
Any nays? Hearing none, the board approves the July 2025 meeting minutes. Next on our agenda is a report from the Office of Open Government. Director Allen, please proceed.
Thank you and good morning, Chairperson Hutcheson and members of the board. I am Niquelle Allen, Director of Open Government, and I am pleased to present this report on the activities of the Office of Open Government. Our mission is to ensure that all persons receive full and complete information concerning the affairs of the District of Columbia government and the actions of its officials. Since the last board meeting, OOG has continued to work to ensure that the district government's operations are transparent, open to the public, and promote civic engagement. To that end, the Office of Open Government has enforced the Open Meetings Act, advised on the Freedom of Information Act's requirements, and provided training on those transparency laws. OOG has proudly served as advocates for an open and transparent government. I will start with Open Meetings Act and Freedom of Information Act advice rendered by the office. First is advisory opinions. Open Meetings Act advisory opinions, Board of Trustees for SELA Public Charter School, number OOG-2024-0011. On July 21st, I issued this advisory opinion in response to a complaint which alleged that the SELA Public Charter School Board violated the Open Meetings Act by only permitting certain content in the public comment section of its open session meetings. The complainant expressed concern that the public comment guidelines provided by the chairperson of the board was viewpoint discrimination because it restricted negative comments. The Open Meetings Act does not require a public body to allow public comment at meetings covered by the statute. The board's bylaws also do not address public comment. Content of speech permitted by a public body in public session is also not addressed by the Open Meetings Act. The complaint was dismissed because there was no basis to determine the board had violated the Open Meetings Act. While the Open Meetings Act ensures that the exceptions to the public rights to view a public body meeting are narrowly construed, it does not extend to an examination of a public body's policies regarding public comment. As such, I found no OMA violation, and I dismissed the complaint pursuant to 3 DCMR Section 10403.1B. A copy of the advisory opinion and the complaint are in Dropbox. The next opinion is OMA advisory opinion regarding the DC Public School Board, Charter School Board, number OOG-2025-0003. On July 25th, I issued this opinion in response to a complaint which alleged that 47 boards of trustees for DC public charter schools are not in compliance with the Open Meetings Act, citing one or more acts of noncompliance by each of the 47 boards of trustees identified in the complaint. The complainant alleged that the information pertaining to the 47 boards of trustees meetings was not accessible to the public, and the District of Columbia Public Charter School Board should articulate standards for all public charter schools to follow when posting their information on their websites to comply with the Open Meetings Act. This advisory opinion addressed the concern that the DC Public Charter School Board should participate in ensuring OMA compliance. OOG is continuing to investigate the allegations against the 47 schools. I dismissed the OMA complaint against the DC Public Charter School Board and found that the public body did not violate the Open Meetings Act. The DC Public Charter School Board does not have an affirmative obligation to ensure OMA compliance. That responsibility rests with OOG. Further, the complainant's allegation that the DC Public Charter School Board should ensure universal, easy access to the Public Charter School Boards of Trustees meeting information and provide a board meeting template to be used by DC Public Charter School Boards on their websites does not implicate the Open Meetings Act and Open Meetings regulations. The opinion acknowledges the DC Public Charter School Board's effort to assist public bodies with OMA compliance, but acknowledges that it is not obligated to do so, and failure to take a particular course of action, as alleged in the complaint, is not an Open Meetings Act violation. A copy of this advisory opinion and the complaint are in Dropbox. Informal advice. Since the last board meeting, OOG has responded informally via email, telephone, or teleconference to requests for assistance as follows: 11 requests for Open Meetings Act advice, 10 requests for FOIA advice, and 10 requests for technical assistance with open-dc.gov. Meeting monitoring is next. OOG staff attends public body meetings in person and remotely to ensure compliance with the Open Meetings Act. They also inspect public bodies' websites and the Office of Open Government Central Meeting Calendar for public meeting notices and records. OOG's attorneys provide legal advice on the Open Meetings Act compliance and take corrective action if necessary. Since the last board meeting, OOG's legal staff attended 12 public body meetings, and as a result of the monitoring, one corrective measure was communicated. The public body failed to publish a cancellation notice of one of its canceled meetings pursuant to the OMA. Training and outreach is next in my report. And first is commonly used DC FOIA exemptions and redaction training to DC FOIA officers. On July 16th, Attorney Advisor Joan Lelma presented this training, and it was the first in OOG's DC FOIA Officers Summer Training Webinar Series. The training covered the most frequently used FOIA exemptions based on the district's annual FOIA report, how to properly apply these exemptions and redact responsive exempt information in accordance with DC FOIA. The training provided key points for preparing response letters to requesters. I, along with OOG staff, attended the training virtually. The 25th Annual Municipal Law Institute Practicing Law Institute. On July 21st, Attorney Advisor Anthony J. Skirbo attended this training. The attendees were provided with an analysis of important developments, emerging legal issues, and best practices for local government lawyers in crucial areas of municipal law, including a review of what municipal lawyers need to know about cybersecurity and technological developments and threats, exploration of the structure of the brain and how areas of the brain may be associated with specific aspects of negotiation and mediation behavior, updates on the latest Supreme Court developments for municipal lawyers, and how to identify and handle ethical issues that can arise for municipal lawyers. Next is DC FOIA litigation update, recent records access cases training to DC FOIA officers. On July 23rd, Attorney Advisor Brandon Lewis presented this training to FOIA officers. It was the second in the Office of Open Government's summer training series and covered specific areas of FOIA litigation in the District of Columbia and provided an overview of impactful DC FOIA cases and significant extrajudicial jurisdictional cases. The presentation included a review of some of the latest appellate opinions from the Mayor's Office of Legal Counsel and the May 16th status hearing. I'm sorry. I'm on the wrong page, sorry. And how to search for them. I, along with the Office of Open Government staff, attended the training virtually. Next is the Office of the Attorney General for the District of Columbia Ethics 2 training. On July 29th, Attorneys Skirbo and Lewis attended Ethics 2 training facilitated by Jeremy Morris, Special Assistant Attorney, Chief Public Corruption Section, and Erica Stillebauer, Ethics and Compliance Officer and FOIA Officer for the Office of the Attorney General. Next is DC FOIA Best Practices, including processes and responses training to DC FOIA officers. On July 30th, Attorney Scarborough presented this training to DC FOIA officers that covered key areas of focus for FOIA officers in handling DC FOIA requests. I, along with OOG staff, attended the training virtually. 2025 No B4 Security Awareness Training coordinated by the Office of the Chief Technology Officer. I, along with OOG staff, completed this training coordinated by OCTO. The training included information on how to identify common cyber threats and cyber safety best practices. This is an annual required training. Next is the litigation and legislative update. Litigation is first. Chicago Justice Project versus the District, case number 22 CA 001175-B in DC Superior Court. I previously reported on this case in which the Chicago Justice Project filed suit to compel the Metropolitan Police Department to release certain records concerning gang tracking and analysis system in a dispute between an advanced fee that MPD demanded for its FOIA review and a similar amount that the Chicago Justice Project demanded in attorney's fees. When I last reported on this matter, the parties were negotiating a settlement agreement at an April 11th, 2025 status hearing. The district's counsel represented that the terms of the settlement agreement had not been met and the case should remain open. At the May 16th status hearing, the court heard heard representation from the plaintiff that the case settled in 2023 and that plaintiff was working with the district with respect to the materials that the district was producing. The plaintiff reported that it was working to reach a resolution with the district, but stated they may be caused to file the motion for in-camera review, and this was actually filed on July 11th. In this motion, the plaintiff asked the court for an order requiring the district to furnish copies of a representative subset of 37 records currently withheld pursuant to DC Official Code Section 2-534A 3A, investigatory records compiled for law enforcement purposes, to the court for an in-camera inspection to determine whether the asserted exemption had been lawfully applied and whether a segregable non-exempt information can and should be disclosed. The next status hearing is scheduled for August 29th. A copy of the motion for in-camera review and the memorandum of law in support of plaintiff motions for in-camera review have been added to Dropbox, and OOG staff will continue to monitor this case. Next is legislation. First, legislative action regarding the Open Meetings Act. On June 30th, Council Bill 260307, Open Meetings Clarification Congressional Review Emergency Amendment Act of 2025, was introduced by Chairman Mendelson. It passed unanimously by voice vote on July 1st and was transmitted to the mayor on July 7th. The bill was returned from the mayor on July 15th, and on July 18th, Act 26-0110 was published in the DC Register. On July 22nd, it was enacted without the mayor's signature as Act 26-0110, and the expiration date is October 20th. The act amends on an emergency basis due to congressional review the Open Meetings Act to clarify the definition of a meeting, to provide for a public body's ability to be briefed about potential terrorist or public health threats, so long as no official action is taken, to exempt from the act meetings between the council and the mayor, provided that no official action is taken at such meetings, and to provide that a meeting shall be deemed open to the public if the public body takes steps reasonably calculated to allow the public to view or hear the meeting while it is taking place, or if doing so is not technologically feasible, as soon thereafter as is reasonably practicable. A copy of the act has been added to Dropbox. Additional legislative action regarding the Open Meetings Act. As I previously reported, Chairman Mendelson introduced Bill 26-200, the Open Meetings Clarification Temporary Amendment Act of 2025, which was enacted on June 26 without the mayor's signature as Act A26-0086, and is now in the congressional review period with a projected law date of September 6. No additional legislative action has been taken on Utah Senator Mike Lee's U.S. Senate Bill 1450, which was introduced in April and referred to the Senate Committee on Homeland Security and Governmental Affairs. A copy of the act and the U.S. Senate bill were added to Dropbox before the board's last meeting. Legislative action regarding the boards of trustees for public charter schools. As I have previously reported on Bill 26-0062, the Board of Trustees Training Amendment Act of 2025, introduced by Council Member Christina Henderson on January 17th. The bill will require members of a board of trustees of a public charter school to complete training programs on best practices for school board governance, which includes training on the Open Meetings Act. It had a second and final reading on July 1st and passed unanimously. On July 10th, the bill was transmitted to the mayor and signed by the mayor on July 21st and enacted with Act number 26-0112. On July 25th, Act 26-0112 was published in the DC Register, and on July 29th, it was transmitted to Congress. The projected law date is October 15th. A copy of the act has been added to Dropbox. Legislative action regarding a government agency's interpretation of its administering statutes and regulations. For the past 2 months, I have reported on this bill, Bill 26-0048, the Council Review of Agency Action Clarification Amendment Act of 2025, which was introduced by Chairman Mendelson on January 13th. On June 24th, the Committee of the Whole filed its committee report, and on July 1st, Chairman Mendelson introduced an amendment in the nature of the substitute concerning the bill. It passed unanimously on final reading. As I informed the board last month, the bill codifies agency deference and clarifies that a reviewing court or tribunal shall defer to an agency's reasonable interpretation of a statute or regulation the agency administers, providing that the interpretation is not plainly wrong or inconsistent with the statutory or regulatory language or the council's intent. The bill is largely in response to the U.S. Supreme Court decision in Luper-Bright Enterprises versus Raimondo, 603 U.S. 369, 2024. On July 10th, it was transmitted to the mayor, signed on July 10th by the mayor, and enacted with Act number 0111. It was published in the DC Register on July 25th and transmitted to Congress on July 29th. The projected law date is October 15th, and a copy of this act has been added to Dropbox. Last is legislative action regarding the Freedom of Information Act. On July 28th, Chairman Mendelson introduced the fiscal year 2026 Budget Support Emergency Act of 2025, Bill 26-0340, which included the Freedom of Information and Clarification Amendment Act of 2025. This bill amends DC FOIA to create a new exemption for particular data the Criminal Justice Coordinating Council and the District of Columbia Sentencing Commission receives from, quote, court, federal agency, or federal established agency. The bill passed by voice vote 10-2 on July 28th. Copy of the bill is in Dropbox. Last in my report is administrative matters, which is the FY26 proposed budget. On July 28th, the council voted to approve the FY26 budget. The vote included an approval of a supplemental budget for 2025. OOG is currently coordinating with the Office of the Chief Financial Officer to close out the FY25 budget and to plan for OOG-related expenses in FY26. This concludes the Office of Open Government's August 7th, 2025 report. I am happy to answer any questions the board may have.
Thank you, Director Allen. Are there any questions for Director Allen? Okay, thank you. Next on our agenda, we'll hear from the Director of the Office of Government Ethics, Ashley Cooks. Director Cooks, please proceed.
Good morning, Chairperson Hutcheson, members of the board. I'm Ashley Cooks, the Director of the Office of Government Ethics. I'm pleased to present this report on the activities of the Office of Government Ethics, OGE. First is an update on the status of OGE investigations. The information reported today regarding OGE's cases will not reflect any status changes that may occur because of actions taken by the board during today's meeting. For open investigations by status, we have 43 matters that are open, 1 matter for show cause hearing for a grand total of 44. For open undocketed matters, we have a grand total of 3. Pending state investigations by status, we have 36 matters that are closed pending collection, 3 matters stayed pending DC Superior Court case, 3 matters stayed for OIG investigation, 2 matters stayed for U.S. District Court case for a grand total of 44. For regulatory matters by status, we have 56 matters that are closed pending collection, 76 matters that are open for a grand total of 132. Again, we currently have 44 open matters and 8 investigations that are stayed. The number of open preliminary and formal investigations includes 10 new matters. The investigative team resolved 10 investigations since the board last met. This total does not reflect the number of complaints that were dismissed for a lack of jurisdiction. The quarterly complaint report for quarter 3 of fiscal year 2025 is expected to be published by the end of next week, to the Bega website with a press release and heat map. We will include copies for the next board meeting in the Dropbox. Next is training and outreach. First is professional development trainings attended by staff. Senior Board Attorney Lynn Tran attended 2 training courses, Ethics and Focus, the case against Michael J. Madigan, and the 25th Annual Municipal Law Institute. Attorney Advisor Shannon Monk took Financially Fit DC at Work. Attorney Advisors Maurice Eccles and Brenda Keels completed the Office of the Attorney General's Ethics 2 training. Investigator Tasia Reed took Building a Win-Win Relationship with Your Manager. Auditor Courtney Walker took Allies and Ops in the Workplace. Approximately half of OGE's staff have completed the DC government's annual cybersecurity awareness training. For trainings conducted by staff, since the last board meeting, OGE conducted 6 training sessions to include the July quarterly outside employment training, 2 new employee orientation ethics segments, the July quarterly boards and commission training, outside employment training for the DC Child and Family Services Agency, and the monthly brown bag session. On Monday, July 28th, Attorney Advisor Brenda Keels presented the July Ethics Council brown bag session titled Nepotism and Conflicts of Interest. 12 ethics counselors attended the session, and a copy of the presentation was placed in Dropbox. During the month of July, 20 employees completed ethics training using PeopleSoft. The LMS recorded 17 course completions while adding 10 new users. Since the beginning of 2025, the LMS has had 1,449 users complete 2,113 courses. The training team has been meeting with LRN to discuss creating new courses and updating existing courses to make them more accessible to users. For outreach, OGE is in the final stages of coordinating Ethics Week 2025. This year's conference will take place on October 14th through the 17th and will include 2 in-person days at the Bega office and 2 virtual days. This year's theme is Keeping Government Transparent and Ethical, and includes sessions that are designed to encourage employees to comply with the ethics, open meeting, and FOIA laws. I'm sure that this year's program will garner the same success as previous years. Next week, OGE will issue its bi-monthly newsletter, Ethically Speaking, and as always, a copy will be placed in the Dropbox. For an update on advisory opinions and advice, for informal advice, OGE's legal staff provided advice for approximately 23 ethics inquiries, which is 7 less than the 30 reported at the July meeting. This number does not include responses we have provided to questions regarding the lobbyist and FDS e-filing systems. For formal advisory opinions, OGE has 2 advisory opinions in the works, one on widely attended gatherings, and an edited advisory neighborhood commissioner sign-on letter opinion. Next is an update on legislation and rulemaking. First is the 2026 Budget and Budget Support Act. On July 28th, the Council approved the FY26 Budget and Budget Support Act. Bega's proposed FY26 budget remains the same, which includes an increase of $139,000 to align with personnel services and fringe benefits, and a decrease of that amount in the non-personnel services fund. When first introduced, the Budget Support Act included language that will revert Bega's special purposes revenue funds to lapsing accounts, wherein any remaining funds at the end of the fiscal year would be sent to the general fund. However, based on the Committee on Judiciary and Public Safety's recommendation, that language was removed and Bega's special purposes revenue will remain as non-lapsing accounts. Next is lobbying registration and reporting. On July 25th, OGE finalized a rulemaking that provides technical amendments to the lobbyist registration and reporting regulations. Specifically, the amendments changed the registration fee and late filing fine amounts to the new fee schedule that was implemented at the beginning of this fiscal year. The amendments also include language that notifies registrants that the best course of action is to file a termination report when they don't intend on engaging in lobbying activity. For OG administrative matters, there are no updates there. Next is an update on financial disclosure statement, FDS. Pursuant to DC Official Code Sections 1-1162.24 and 1-1162.25, public officials and certain government employees must file a financial disclosure statement as a means of transparency and to prevent engaging in conduct that violates the Financial Conflict of Interest statute. Bega is responsible for ensuring that employees and public officials who meet the statutory requirement file their annual financial disclosure statement. The 2025 financial disclosure season has closed, and the FDS deadline was May 15th. OGE opened the season with 10,147 names in the e-filing system. Nearly all agencies have submitted their financial disclosure review reports with addendums. Staff reviewed documents and adjusted the total number of designated filers to 9,603 filers. With the adjusted numbers, the 2025 FDS season has had an overall completion rate of 92%. The final step is to finalize the enforcement list and send fine letters to non and late filers. For an update on lobbying registration and reporting, LRR, pursuant to DC Official Code Section 1-1162.27A, a person who receives compensation or expends funds in an amount of $250 or more in any 3 consecutive calendar month period for lobbying shall register with the Director of Government Ethics and pay the required registration fee. According to DC Official Code Section 1-1162.30, Each registrant shall file quarterly reports concerning the registrant's lobbying activity during the previous quarter. The second quarter reporting deadline was July 15th, and notices were sent on June 16th and June 30th. In response to the deadline, 449 activity reports were filed using the e-filing system. Additionally, staff responded to 36 support tickets as well as several phone inquiries. Enforcement for first quarter enforcement is underway, and fine letters were sent on July 31st. The second quarter report was generated and is being reviewed. Additionally, staff identified 51 lobbyists and clients needing complete registration filings. Letters went out on July 30th. Program Coordinator Kosick has been meeting with these registrants to gain compliance. Last is an update on public investigations. 24-0016F and 25-0002F Henry Trayon White. These are formal investigations based on the criminal indictment in which respondent, council member for Ward 8, allegedly agreed to receive $100,056 in bribes and accepted $35,000 in cash from a business owner in exchange for assisting with renewing the company's violence interruption contracts with the DC government. And 2, allegations that the respondent violated the code of conduct by failing to file a full and complete public financial disclosure statement pursuant to DC Official Code Section 1-1162.24. Investigation 24-0016F is stayed pending the outcome of the criminal court case, which is scheduled for trial on January 12, 2026. Last month, the board issued a notice of violation in 25-0002F based on respondents' failure to file financial disclosure statements for November 2024 and May 2025. Thank you. This concludes the Office of Government Ethics August 7th report.
Thank you, Director Cooks. Are there any questions for Director Cooks? Okay. Hearing none. The next item on our agenda are public comments. Members of the public in attendance at this meeting have an opportunity to make a comment at this time. Are there any members of the public? Okay. If there are no comments from the public, we will proceed with the next item on the agenda, and that's our executive/closed session. This is to discuss ongoing confidential investigations pursuant to DC Official Code Section 2-575B14, to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code Section 2-575B4A, to discuss personnel matters, including the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code Section 2-575B10, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code Section 2-575B13, and to discuss contract negotiation strategies pursuant to DC Official Code Section 2-575B2. May I have a motion to enter into executive session?
So moved.
Is there a second?
Second.
Okay, it's been moved and seconded that the board enter into executive session. All those in favor, please signify by saying aye.
Aye. Aye.
The motion passes unanimously. Board members, please move over to the boardroom for the executive session. We will return to this meeting at the conclusion of the executive session to report out any matters decided, finish any other business, and adjourn the meeting. Thank you. Okay, the time is now 11:10 a.m. and we are back on the record. In executive session, the board approved a notice of violation in matter 24-0007-F in Ray Mark Davis. The board also approved a notice of hearing and scheduling order for matter 25-002F in Ray Trayon White. Now still 11:11, and this concludes the meeting of the DC Board of Government Accountability. The next board meeting will be held here at the Board of Ethics and Government Accountability, 1030 15th Street Northwest, Suite 700 West, and virtually on September 11th, 2025 at 10 a.m. Thank you.
Folks, see you next month.
See you next month. We're adjourned. I'm sorry. We are